In Pakistan in the year 1983, Jehan Mina's name became public news. She was a 15-year-old girl who suffered from rape at the hands of her uncle and his son, yet endured compound suffering at the hands of those responsible for achieving her justice thereafter. After filing a complaint with the police, she was charged and sentenced for zina, which are extramarital relations under Islamic law, based on evidence of her pregnancy outside of marriage. Though, on the basis of her young age, the judge reduced her lashing, usually 100 to 10 lashes alone with 3 years imprisonment. This reduction in punishment does not eliminate the fact that not only was she punished, but her rapist went off scot-free. The Pakistani Hudud Ordinances, which was the catalyst which laid the path for such injustices, were introduced by the then military ruler of Pakistan, General Zia-ul-Haq, in 1979 as a part of the Islamization process. As we'll come to see, these ordinances were an amalgamation of competing formulations of Islamic law, which in combination create an oppressive legal environment for victims of rape and consequently unjust determinations in a court of law. Welcome to another episode of The Religion Inquirer, a channel dedicated to investigating religious thought, history, and influence classically and in more modern times, with in-depth research into academic publications and opinions in the fields of theology, philosophy of religion, and religious law. Without further ado, let's dive in and explore the topic of rape and Islamic law in the modern period. It is incidents like that of Jehan's that create public uproar and instigate investigations into the validity of Islamic law as a just system for a country's citizens. High-profile cases, ones that create outrage, are especially useful in drawing public attention and facilitating the changing of policy to support victims. This is because politicians, interest groups, advocates, and activists have a wide range of issues to choose from as it relates to the public sphere, with limited resources to embark on such pursuits of justice and reform. Under these restraints, events that spark public outcry are particularly useful in this regard, as they serve to identify an area of focus requiring urgent attention and policy reform. It is not only the event itself, but the schematic framing of the event and its important components that work in enactments' favor to garner public and political support. In response to incidents like these, academics have formulated different views on the question of whether the contemporary form of Islamic law in Muslim countries really stays true to classical formulations, or instead is a function of colonial influence on the articulation of Sharia. Some academics claim that classically, jurists considered rape under the category of hiraba, which is brigandry, or jarh, injury, though as we'll see by looking at the primary sources in the form of standard legal reports, which include the sayings of the Prophet Muhammad and those of his successors, this is not the case. Collections of these reports utilized to embark on this investigation include the canonical work of Bukhari, the most reliable book after the Quran, the Muwatta of Imam Malik, and other collections of legal reports. Through careful investigation of the prevailing consensus during the period of formation of Islamic law, namely in the first 3 centuries after the introduction of Islam, this video will aim to demonstrate the juristic discourse in the formative period of Islam that contributes to the formulation of unjust contemporary enactments of Islamic law. Classically, jurists unanimously agreed on the classification of rape under the category of zina, which is extramarital relations, a crime which transgresses, according to Islamic law, against the rights of God, and which requires as punishment the implementation of the Hadood. The Hudud are a form of divine penalty that, by their very nature of the penalties, as injurious and harsh, personifies the ultimate power and might of God. Other Hudud penalties, which have received considerable news coverage, and which exemplify the egregious nature of such punishments under this legal category, are the cutting off of hands of the thief and the stoning to death of the adulterer. When it comes to zina in particular, this is punishable by means of 100 lashes directed towards both parties in consensual cases and the accused in the case of coercion. This unanimous categorization of rape under the heading of zina, requiring the Hudud punishments, is demonstrated by the various reports involving the Prophet Muhammad as well as his companions and successors, ruling in cases of coercion that the accused be punished under the had. One such example in the life of the Prophet is an incident of a free woman who went out to attend prayer, where she was approached by a man who sexually violated her and fled. She then alerted passers-by who brought what she believed to be the man before her, whom she positively identified as the culprit. They went to the Prophet, who commanded that the man be stoned. But before this could be carried out, another man came forward, expressing that it was in fact him who had violated the woman. In response, the Prophet ordered that he be stoned instead, and the woman received no punishment. Also, there exist numerous reports of the close companion of the Prophet, Umar ibn al-Khattab, the second caliph, for ruling in cases of sexual coercion. One such example is the case of a male slave who was put in charge of war captives and sexually assaulted one of them, in which case Umar imposed flogging on him in addition to exile. Similar judgments were made by successors such as Umar ibn Abdul Aziz, who ruled that an Abyssinian slave who coerced a woman be subjected to the had punishment and required to pay a monetary sum to the victim. In addition, legal opinions of the period also follow a similar line of categorization and reasoning. Legal scholars such as Zuhri, Hassan al-Basri, and Ata ibn Abi Rabbah all concluded that the sexual coercer be punished with the had. It is this categorization of rape as zina that problematizes the Islamic approach to rape criminalization, in tandem with other evidentiary standards which are specified under crimes against God. As a victim of rape, legal doctrines of non-culpability play a role in the trial, because through the act of coercion, the aggressor relieves the victim of any responsibility or culpability, given that the victim faces physical force or threat of such force, which impedes their decision-making ability and overcomes their will. Though this is favorable for the victim of such a heinous crime, the issue arises in proving this coercion in a court of law. Like consensual zina, in a parallel analogical category, coercive zina requires that a victim's testimony be corroborated by 4 male upright individuals who witnessed the act of penetration, or the accused confesses to the crime themselves. This is especially problematic as it creates an almost impossible evidential barrier standing in the way of the victim achieving some form of justice. The binary between classifying rape as a violation of a theocentric right, which is the Hudud, or an interpersonal right, is the dividing line between jurists who conceptualize how rape should be treated under Islamic law. The Hanafi school distinguished rape as a violation of a theocentric right, the right of God, and as discussed earlier, conceded that the punishments and evidentiary standards meet those of the analogical category of consensual zina. In the case of consensual zina, based on a prophetic tradition, which advised on the avoidance of issuing the had punishments, such evidentiary standards were lenient for perpetrators of consensual sex. But when it comes to the issue of coercive zina, or rape, these same charitable leniences were grave methods of injustice, tarnishing almost any possibility of a victim's quest for justice by effectively protecting the rapist and criminalizing the victim. It is due to the inadmissibility of circumstantial or indirect evidence in terms of theocentric framing that this is the case. Furthermore, on the testimony of the 4 upright male witnesses, if a witness did not use the phrase "I testify" and instead used less indicative phrases such as "I know" or "I'm certain that," his testimony would not be accepted, and instead, all witnesses, including the victim, would be trialed for slander and face the punishment of 80 lashes. Also, if any of the 4 witnesses were different on any aspect of the act, such as the time, place, their testimony would then too be invalidated. In addition, further diminishing the chances of justice for the victim, Hanafi jurists claimed that testifying in had crimes was neither obligatory nor recommended, and rather advised that a witness should conceal their testimony in order to ward off the had punishment, because of the command of the Prophet to, quote, avert the Hudud to the extent that is possible. The only exception to this legal advice was the case of theft, because scholars considered it an interpersonal violation and the potential testimony as assistance to the aggrieved party. One may question then, how was rape not seen in the same light? And this goes back to the theocentric framing of the crime, which did not hold the crime as a violation of an interpersonal right of the victim, but instead a crime against God. The Maliki school, in addition to its categorization of rape as zina, classified rape under iqtisab, which is a proprietary crime which allowed for considerably more lenient evidentiary standards than those of zina, and granted victims the ability to claim indemnities with only 2 or even 1 witness, including the admission of circumstantial evidence. Defining rape in this way centered the victim as the one from whom a right was taken, which is what leads to monetary compensation and a discretionary punishment for the accused. In this case, though not physical property, a victim's sexuality became the object of usurpation. Maliki jurists also demonstrated unanimity in regards to the rape victim's testimony as not being utilized as a confession of zina. Though, given that circumstantial evidence was admissible, the Malikis were unique in using pregnancy as a proof of the guilt of extramarital relations. This is taken from a hadith of Umar ibn al-Khattab, a companion of the Prophet Muhammad, who said, "Stoning is in the Book of God as a right upon whomever commits zina who is muhsan, whether man or woman, if there exists eyewitness proof or pregnancy or confession." Because the Malikis did not consider the testimony of the victim as an admission for prosecuting zina, it avoided a disastrous situation for the victim whereby, because of the pregnancy, they would be forced to come forward and witness to their being raped, regardless of how much evidence they had, and under such circumstances also faced the higher chance of being subjected to a harsh had punishment on account of their testimony being used against them on a zina charge. This was essentially the situation of Jehan Mina, who was mentioned earlier, because it was her pregnancy that was used as evidence, as in the hadith of Umar ibn al-Khattab, against her after coming forward. Jurists also brought to the table the reputation of the accused and the victim when it came to weighing the evidence in a trial. If the woman was not persistent in her claim against him, the rapist, and he held an honorable reputation in the community, then the charges against him could be completely dropped, and he would not be obligated to pay a monetary compensation, nor be liable for a discretionary punishment advised by the judge. Similar to traditional laws in the US before the reformation of traditional rape laws in the 1980s, Maliki jurists used reputation as a generally valuable standard of investigation, which led to investigating even the reputation of the victim, which in turn played a substantial role in regards to their claims. It should also be noted that judges can disqualify witnesses based on their gender alone, according to Islamic law. This is because in order to convict for the had punishment, the evidence in favor of the conviction must reach a level of certainty. This gender exclusion is targeted at women because in the case of women's testimony, this becomes a doubtful area which does not reach the level of certainty. The basis for such an assertion comes from hadith narrated to this effect, stating woman's deficiency in intellect. This is the opinion of Shafi'i, the eponymous founder of the Shafi'i school of thought, who states that in every context except the exception of financial contracts and the intimate details of women's lives, where two women equate to one man, woman's testimony is categorically rejected on the basis of doubt, which include the cases of criminal trials. This gender restriction in the cases of criminal trials was not only the opinion of one eponymous founder, but also the opinions of Ahmed ibn Hanbal and Malik ibn Anas, as well as other scholars including Ibrahim al-Naqi, al-Hasan al-Basri, Ibn Shihab al-Zuhri, and al-Lays ibn Sa'd, amongst others. So how does this information regarding the Islamic conception of rape in Hanafi and Maliki schools lend to our understanding of unjust applications of Islamic law in places like Pakistan, in the case of Jehan Mina? Essentially, we find that in these circumstances, there seems to be the creation of a quasi-Islamic law formulation, whereby doctrines of various schools are meshed together to enable the injustice faced by victims of rape in places like Pakistan. In the case of Jehan Mina, she was forced to come forward with her rape claim, given her pregnancy, which she discovered after a significant amount of time had passed following the incident. But given that Pakistan upheld geocentric framing of the crime of rape, she did not reach the bar of evidence needed to prove her claims, leaving her in a situation where her testimony and pregnancy formed into a confession for zina, a crime punishable under the severe had punishments mentioned earlier. Because Jehan Mina's case was in the 1980s, a question may arise as to what happens now. Due to widespread coverage of Jehan's case, as well as an accumulation of unjust turnouts for women victims of rape in Pakistan as a result of the Hudud Ordinances, the ordinances were revised and the Protection of Women Act was introduced in 2006, which dramatically altered the fate of female rape victims at the time. Though the Council of Islamic Ideology, CII, one of the two bodies responsible for ijtihad, which is Islamic legal reasoning, stated that the Women Protection Bill was un-Islamic. This dissatisfaction with the bill was rooted in facilitating the movement of rape under the Pakistan Penal Code, making it a civil law and not a had determination, but rather a ta'zir punishment subject to judiciary discretion. In the same vein, in 2013, the CII declared DNA tests unacceptable as primary evidence in the case of rape charges and re-endorsed the requirement of 4 male upright witnesses to corroborate the claims of the victim. This was obviously met with much criticism, and rightly so, as it was seen to overburden the rape victim with a nearly impossible bar of evidence, which was one of the hallmark injustices of the initial Hudud Ordinances of 1979. In most recent times, however, much has changed since the Hudud Ordinances, with a new Anti-Rape Act coming into play in 2020. Pakistan has taken a harsh stance against the crime of rape in the country. The advancements include more severe repercussions for the accused, more modern forms of investigation, and evidence and expedited trial processes in place to ensure a faster path towards justice. Despite these advancements, the question still remains as to whether a strict adherence to classical Islamic law, such as the Hanafi conception of rape law, for which Pakistan remains a largely Hanafi region, continue to serve the Muslim community in their pursuit of justice, or whether there is a way to stay true to classical conceptualizations while acknowledging and paying due attention to the upholding of women's rights. Because the Hudud involve a set of legal standards, is it possible to stay true to these commands for justice by an all-knowing deity in light of modern standards of evidence? And how would this play out? How would such reformation fare in light of orthodox readings of Islamic scripture and commands? And what does this mean for the alleged timelessness of the text and legal reports? I will cover the issue of Islamic reform and what this means in other articles and videos. As for now, as evidenced by this video, we've seen in a manner in which the Sharia law as formulated in classical Islam can prove detrimental for female victims of sexual crime, and how the removal of Hudud ordinances in Pakistan led to a higher standard of justice for female rape victims. So the question remains as to how formulations in Islamic law can be incorporated in our day and age, and whether it stays true to the spirit of the law. In other videos, we'll go over this, but now this has just been the religious inquiry of rape and classical Islamic law. I will see you in other videos for other religious inquiries, and I hope this has benefited you as much as it has benefited me. For references, you can check the description box, and I'll see you in the next video. Take care.